Hello everyone, Assalamu alaikum. Welcome to the fourth webinar of our knowledge building series featuring Musawah's research initiative on reclaiming adl and ihsan in Muslim marriages between ethics and law. Thank you for joining us from all over the world. We're really honored by your presence and support, and we hope that wherever you are joining us from, you and your loved ones are safe and healthy. My name is Sarah Marceau, and I'm the coordinator of Musawah's knowledge building working group, and I will be the housekeeper for today's event. With this series of webinars, we are trying to open new digital spaces for building and sharing feminist knowledge on family relations. The topics are evolving around the diverse, plural, and flexible understandings of marriage practices, laws, and ideals in Muslim context. With the first two webinars, we had the chance to dive deep into the fiqh tradition. Our scholars gave us some key tools to understand and explore usul al-fiqh while revisiting fiqh rulings and marriage. Our last webinar featured Dr. Huda Al-Saadi, who took us on a journey throughout history to unearth Muslim women's voices and marriage practices in pre-modern Muslim Egypt. You can watch all our previous webinars in our Musawah YouTube channel. And today we're blessed with the presence of three groundbreaking scholar activists who have been engaged with Musawah from a very long time and in different capacities, Dr. Zahia Jouirou, Professor Lynn Welchman, and Dr. Marwa Sharafeldin. And in a conversation with Jana Rumminger, they will explore ways in which contemporary family laws and legal practices have been reformed in recent years to embrace gender equality. So we have all of the ingredients for an exciting and enlightening webinar that hopefully will speak to some of the pressing issues in your different contexts. Before I hand over to my colleague, Jana Rumminger, who will be the moderator for this session, I have a few housekeeping items to share with you. First, the webinar is also being live streamed via our Facebook page and will be available on our YouTube channel later. Participants that are joining us on Zoom will be able to ask questions using the Q&A button at the bottom of the screen. If we don't get to your question during today's webinar, please don't hesitate to get in touch with us via the email that is on the screen right now. Please do not use the chat function to ask questions. Only use that if you are experiencing technical difficulties, and I will be there to assist you. If in the chat box, I will be also sharing some resources and links to any reference material that the speakers are mentioning, and we will also share them in our website afterwards. If you are tweeting or posting about the webinar, please don't hesitate to tag us at Musawah on Twitter and at Musawah Movement on Facebook and Instagram. Now let me introduce you to our moderator, Jana, who is with us before Musawah was even born. She's a wealth of knowledge and have contributed in so many ways to Musawah's growth. Jana has worked with Musawah in a variety of roles since 2007. She's now an active member of our knowledge building working group. She's been involved in writing and editing many of Musawah's publications, including co-editing Men in Charge, Rethinking Authority in Muslim Legal Tradition. She has worked with a number of women's rights organizations in South and Southeast Asia and also nonprofit organizations in the United States. So we are very happy to have Jana here moderating this discussion. Thank you. And now I'm going to hand over the webinar to you, Jana.
Sarah, and hello, everyone. Welcome again to the fourth webinar of the Musawah Knowledge Building Series to our research initiative on reclaiming adl, or justice, and ihsan, or beauty, goodness, and care in Muslim marriages between ethics and law. We're so excited today to welcome Doctors Zahia Jouirou, Marwa Sharafeldin, and Lynn Welchman to share some of the approaches that have been used to support reform of family laws in ways that furthers equality and justice in Muslim contexts. We're also thrilled that based on the registration data we've received, we feel like we have a real mix in the audience that include activists from a number of countries and academics and students and lawyers and policymakers. So welcome to everyone. Musawah's research initiative on reclaiming adl and ihsan in Muslim marriages builds on our first research initiative on Qawam and Wilaya, which investigated the root causes of gender inequality in Muslim legal tradition and the disconnects between what the laws say and how families actually experience them in reality. This new initiative is an attempt to move beyond those inequalities and disconnects. How do we use ethical and legal frameworks in the Qur'an, in fiqh, in universal principles, and in contemporary lived realities to build marriages that are based on justice, on goodness, on mutual care? We've commissioned a number of scholars to write papers on this topic from different scholarly traditions, and the webinar series is built around those draft papers. So today's webinar is featuring three authors who will focus on the state of personal status codes or Muslim family laws related to marriage and how these laws have been and can be reformed to embrace equality. We're thrilled to have this exciting panel of scholar activists who will share their research and insights. The webinar is of particular significance to Musawah because we have recently launched a campaign for justice in Muslim family laws that brings together advocates to build support at national, regional, and global levels for the urgency of family law reform towards equality and justice. One of Musawah's aims is to democratize both production of and access to knowledge by tying scholarship with activism. Today's webinar addresses this directly with scholars sharing ideas and inspiration for activists and scholars who have joined us. We're also producing a series of policy briefs on arguments that can be used to promote equality on specific topics within family laws. So our topics such as child marriage, equality within marriage, divorce laws, etc. So let me introduce the panelists. Dr. Zahia Jouirou is the director of the Institute of Translation of Tunis and a professor of Islamic and Religious Comparative Studies at the University of Manouba. She specializes in family laws, fiqh, fatwa, and usul al-fiqh, and has published extensively on the status of women in fiqh-based laws. Dr. Jouirou is a member of a Tunisian network of women's groups and was engaged in the campaign to safeguard women's rights in the Tunisian constitution after the revolution. She is an inspiring woman to all of us and is the recipient of several prominent awards and distinctions, with most recently a February 2020 award from the Tunisian Minister of Women, Family, and Childhood in recognition for her contributions to improving women's status and rights in Tunisia. Dr. Marwa Sharafeldin is an Egyptian scholar activist. She has a PhD in law from the University of Oxford, and she is the senior technical advisor and MENA region expert in Musawah. Her work covers the intersection between Islamic law, international human rights law, and feminist activism. She has been published in academic books and media platforms, and she has contributed extensively to UN platforms on women's rights and gender justice. She co-founded and has served on advisory boards of several feminist organizations worldwide, and she believes in the power of art for social transformation, and she's a story collector and an inspiring performer and writer. Professor Lynn Welchman teaches at the SOAS School of Law, University of London, United Kingdom, where she specializes in law and society, Muslim family laws, women's rights, and human rights in the Middle East and North Africa. She also has published widely in her research areas, and many of her articles and books are core readings about Muslim family laws. Before joining SOAS in 1997, she worked in human rights with Palestinian NGOs on the West Bank and international organizations, mostly in the Middle East. She's a board member of the Euro-Mediterranean Foundation for Support of Human Rights Defenders, a member of the International Advisory Board of the Open Society Foundation's MENA office, and a founding co-editor of the Muslim World Journal of Human Rights and the Oxford Islamic Legal Studies series. In 2007, she established the International Human Rights Clinic at the SOAS School of Law. So you see, we have an inspiring panel of hard-hitting scholar activists, and I want to welcome the three of them. So we hope to have a lively discussion around various pathways that activists and reformers can strategically use to create opportunities for equality in family laws. So let's begin. So Lynn, I'm going to turn to you first. Perhaps you can start with some framing of the issues and the various components involved in these issues. We sometimes talk a little bit kind of vaguely about Muslim family laws and reform and how these laws are situated within broader legal structures. I'm wondering if you can give us a bit of explanation and structure for how to think about Muslim family law reform in context. Over to you, Lynn. Thanks.
Thank you, Jana. Thanks to Musawah, and hello everyone. It's very exciting to be sharing this event with Marwa Sharafeldin or Zahia Jouirou. We've been working together on a paper for Musawah's knowledge building project, and so the work we're presenting today is part of that experience, comes out of that. And we're going to be looking at some of the pathways to change that provides institutional support for strengthening the input of the egalitarian Quranic ethics of equality, justice, and care into the text and practices of Muslim family laws. Just to start, substantively, Muslim family law as a term covers the heterosexual spousal relationship, marriage, how it's conducted and how it's ended by death or divorce, the parental relationship, rights and obligations arising between parents and children, and also child custody and guardianship, succession, and other family relationships insofar as they give rise to rights and obligations such as maintenance of minors, responsibility for children, and so on. Muslim family law matters to mothers, grandmothers, daughters, sisters, aunts, wives, and all their male peers and equivalents, whether we're talking about statutory form or an idea of what Islam does or does not, or indeed could require of a spouse, a father, or any other family member. It governs their most intimate sets of relationships and also configures relations with the world outside the family, including variously the worlds of education, work, property, politics, and resource distribution. In embarking unapologetically upon the objective of reform in the egalitarian ethics framework, we proceed from the findings of many scholars and activists that Muslim family laws as currently codified remain largely the result of patriarchal interpretations of the source texts and indeed contexts that have given rise to formulations of male authority that stand in contrast to the normative principle of human equality. Now, of course, this is all very broad, and nowhere in the world has that normative principle of human equality been fully achieved. But in terms of our work, and in this paper, key among the challenges are the juristic and legislative articulations of qawama and wilaya as male authority in the spousal relationship and male guardianship over females in the family, very broad. Such constructions of male authority in the family are by no means particular to Islam or to Muslim family law, but there are particular challenges in addressing how they might give way to the principle of equality and the Quranic ethics of justice, equality, and care. These two institutions, qawama and wilaya, are presented as part and parcel of what we, in our paper, call the Shari'i postulate, where postulate is referring to an underlying system or set of moral or religious imperatives that are understood to frame earthly endeavors such as laws regulating the family. Challenging male authority in Muslim family laws is readily equated with challenging established interpretations of Sharia and therefore the Shari'i postulate. And for many and varied reasons, Muslim family law is widely perceived and presented as governed at least ultimately by the Shari'i postulate. As we understand it, this current part of Musawah's work includes trying to bring the egalitarian Quranic ethic to bear on the meanings of the Shari'i postulate. That's where it lies. Musawah's framework from the start articulated 4 focuses of attention in their struggle for gender equality. And these 4 are Islamic teachings, universal human rights, national constitution guarantees of equality and other national legislation, and the lived realities of women and men. And this framework for research and action reflects certain theoretical academic developments in the conceptualization of lawmaking and normative authority. This is interesting. One theoretical framing of living law that Musawah has found of practical use, borrowing from Werner Menski, pictures the 4 corners of a kite, each representing different sources of normative authority, overlapping and competing with each other, contesting and confirming, pushing and pulling, and all this in specific situated contexts. The 4 corners of the kite reflect the 4 focuses of Musawah's practice-oriented research. The corner relating to religion, ethics, morality includes legal postulates for our work, the Shari'i postulate, and Musawah's focus on Islamic teachings. The other corners, very broadly, are society, which includes lived realities for Musawah, state law, including constitutional law, and international law, which matches Musawah's focus on universal human rights, and in particular, the equality norm, which itself, of course, is developing rather than static in meaning. We try to bear these endlessly dynamic configurations in mind in our paper, examining how, in the interstices of the kite's corners, multiple factors come together to create change that goes in the direction of gender justice and equality in Muslim family laws. For today, we're going to focus on examples only involving religious-based arguments in constitutional law, then efforts to combat violence in the family, and then procedural approaches to Muslim family law reform. Thank you.
Thank you so much, Lynn. So this is super interesting, I think, that there's this idea of there are a number of forces and they're all evolving and developing themselves, and they're pushing and pulling on Muslim family laws, and all may have an impact on the laws themselves as well as the strategies for reform. And so that can lend itself to different approaches that can be taken in different contexts to make the reform actually happen, or to realize equality in other ways, I guess. So one approach, of course, for law reform is to substantively change the individual provisions in the laws, or even to overhaul the whole law, as in the case of the Moroccan Mudawwana. But often in the case of Muslim family laws, there may be resistance to such changes based on religious arguments, that the laws are sacred and that they cannot be changed. And so now I'm going to turn to Dr. Zahia. Zahia, can you speak to us a little bit about how reformers have used religious-based arguments and constitutional arguments to get around resistance based on religion and to push for substantive changes of religious-based law. Over to you, Dr. Zahia.
Thank you, Jana. Thank you, everyone. Assalamu alaikum wa rahmatullahi wa barakatuh. First of all, we can't speak about our least struggle in Tunisia, which is the struggle for equality in inheritance laws, which is the example that I will take to speak about the religious arguments and about the use of the reform, about the reform through the constitutional purposes, without having an idea about the historical background and the sociological context. About the first point, we can say that from 1930, the struggle for inheritance equality began with the Tahir Haddad book, Our Women Between the Sharia and the Society, in which he was the first and only Muslim scholar who said that equality between men and women in inheritance laws must be established because equality is the final God's purpose, and that the inheritance verses are not immutable and decisive as the traditionalist scholars say. Then between the 60s and 70s, Tahir bin Ashur, who written a tafsir Tahrir wa Tanwir, he demonstrates in this tafsir the same thesis, that the inheritance verses are not immutable and decisive. And he said also that the Qur'an doesn't depend, that the meaning of the Qur'an doesn't depend on the text only, but also on the mufassir and his approaches and his context. And also in his theory on maqasid al-sharia, Tahir bin Ashur added equality as a God's purpose that is inseparable from justice and equity. In 1973, the Tunisian President Bourguiba suggested to establish equality between sons and daughters in inheritance laws, but his suggestion wasn't accepted by the traditionalist ulama. Then, between 1995 and 25, after which is Feminist Association had organized a campaign on equality and published 2 volumes where we find many arguments for equality, sociological, cultural, religious, and juristic, and lived realities arguments. Then in 2014, and with the new constitution, from then, the main purpose of the women and NGOs and civil society struggle, and some political parties also, was the reform through constitutional purpose, based on the constitutional principle of equality between all citizens. The political will to promote women's rights is manifested by the introduction and support of various reforms, but also by setting up mechanisms and institutions facilitating the implementation of reforms. In 2017, the President of Tunisia charged a committee, what is called Committee for Individual Freedoms and Equality, to look after the constitution, to look after the CSP, the Tunisian status laws, to put all all the Tunisian laws in concordance with the principle of equality between all the citizens that is said in the constitution. We know that in Tunisia, the inheritance as a mode of transmission of property is governed by laws inspired by the Maliki school. But also the most problematic case where the father dies leaving girls and boys, the latter inherit a share double that of the girls. And the Tunisian law, the most problematic case in the Tunisian inheritance law is this case. That's why all the struggle of feminists and political parties and the civil society is to change this case by establishing equality between the girls and the boys, between the deceased's daughters and son. And the debate about this case is usually it emerges at many times, and it reappear again from the 70s until now. And the actors in this debate can be divided according to their position vis-à-vis the half-share rule. We find, first of all, actors who do not accept any debate regarding this rule. They are mainly preachers, traditionalist scholars, Islamist thinkers, Islamist politicians, and they exclusively adopt a religious and especially a fiqhi frame of reference. Second, actors are the actors who demand equality based exclusively on secular frame of reference. Then the third actors are whom mobilize a mixed religious and secular framework in order to claim equality in terms of inheritance. They are Islamic and secular intellectuals who reflect on the sacred text, their context of revelation, the purpose and intention of God, the maqasid al-sharia, and the modern socio-economic context. They try to show that a change of the said rule from within the Islamic frame of reference is possible. The Colib is the noun of the Committee of Individual Freedom and Equality report adopts this approach in reinterpreting the inheritance verses with reference to the constitutional purposes and to the international conventions ratified by the Tunisian government, especially the CEDAW, which Tunisia had officially lifted all reservation against it in 2014. Concerning inheritance and to justify its call to establish equality, the committee has opted for an interpretation intended to be progressive of the Qur'an and the precepts of Islam. They said in this, the committee said in this report that Islam has responded to the call for justice from the women in the beginning and for equity in order to establish absolute equality between men and women in their rights and obligations, while mentioning 3 verses from the Qur'an which ensure the existential and substantial equality between the 2 sexes, and they use especially the verse 13 from Surah Al-Hujurat. The Commission deduces from this verse that equality between men and women is today an application of the precepts of the Qur'an at a time when new social balances emerged following radical changes which affected all the aspects of life. They said in this report also that Islam cannot be understood outside of its historical context. They said also that we need to emphasize the need to recontextualize certain religious texts because society has changed. They use especially the concept of ijtihad, which means adapting the precepts of Islam to the lived reality. They also recalls that the Qur'an, in the Qur'an, only parents, daughters, sons, brothers, and sisters are mentioned as heirs. But, however, the prophets and his companions and the fuqaha have inherited grandparents, uncles, and grandsons, and that means that the inheritance laws have been subject of ijtihad during the Islamic history. They used many Shari'ic arguments. For example, they used the cultural or historical arguments. They compare between the transmission of property before Islam and after Islam, and across this methodology, they understand that the goods were reserved, that the property of the deceased did not return to those of his descendants among his young children and his wives, and did not, the property is used it's for the warriors who participate in the fight for the tribe and for and not for the descendants. They also use another argument that the advent of Islam and the regulation of inheritance and the rule of regulation has evolved as the Muslim world grew and structured, and they use many examples to show how the inheritance laws have been changing throughout the Muslim societies and throughout the history. That's why they said that history teaches us that the rule have never been sacred, and it is important to note that the provisions relating to civil affairs have not been through space and time immutable, but very changeable and moving because they are confronted with the social reality in the various fields, including in matter of inheritance. They show how we find many laws that are unified through all the Sunni schools and all the Muslim schools, Sunni or Shi'i, but also we find many many differences, and they use the differences between the different fiqh schools to show that the inheritance law is a matter of ijtihad. It's a subject of changes through the societies and the historical periods. They also show that many Muslim reformers in the modern times give the inputs to equality between women and men by the reinterpretation of the Quran in the light of the Quranic ethics and God's high purposes. And from this point of view, we can argue that Muslim law aims in its spirit to achieve equality, justice, and equity that Islam, in his essence, does not object to the achievement of equality in all areas by taking into consideration the women's participation in socio-economic and cultural life. We should accept the principle of changing laws for changing societies. They use also the commitment of many ulama in favor of equality. For example, they use the book of Tar Haddad, the ideas of the Sudanese Mahmoud Muhammad Taha, of the Pakistani Muhammad Iqbal, of the Syrian Muhammad Shahrur, and Nasr Hamd Abu Zaid, and they use their arguments to show the progressive character of the prescriptions of Islam, which have sought to adapt to the context and to the social progress. All these ideas in the committee report are used to show that we must find something. We must find the combination between what is said in the Constitution and how we can understand the religion and the Islamic prescription to show that it is possible that we can find possible solution for equality between men and women in inheritance laws.
Thank you so much, Dr. Zahia. I was just about to give you another warning that the time was over. So this is a perfect concrete example of the various forces that are pushing and pulling on one another, right? The Tunisian activists are working in strong civil society coalitions. They bring together religious arguments, such as ideas around interpretive approaches. They bring together constitutional arguments, such as the concept of equality between all citizens. And they bring together human rights arguments, such as SIDA, to work for the reform of inheritance laws. And I think they also look at this, Dr. Zahia's point about understanding the sociological context is incredibly important in this process. So the strategies that these activists are using and the arguments that they're using have to work for the time and place and take advantage of the current political and social and economic situation. So this is an example of progress in inheritance laws, which are sometimes considered the most untouchable of all areas of law reform. Just wanted to note for the audience, for those of you who have questions for Drs. Lynn and Zahia, you can type them in the Q&A box, and we will get to hopefully at least 20 minutes of Q&A after all our speakers have presented. Okay, thank you, Dr. Zahia again. Marwa, I want to turn to you. Can you please give us another example of an approach that countries have adopted to reform laws related to family and gender relations? Thank you. Marwa, I think you're on mute still, so can you? Thank you.
Thank you. So one of the approaches that governments and reformers in general have resorted to instead of reforming the Muslim family law was to reform other laws or have passed new laws completely altogether. For example, domestic violence laws, or amend existing laws like the penal codes that are somewhat less sensitive to change than the family law. So on domestic violence, for example, let's look at the numbers here in front of you on the screen. I'm looking at regions with a concentration of Muslim family laws, so the Southeast Asian and the Arab regions, where we find that the numbers on domestic violence, especially by intimate partners, are the two highest in the world at 37.7 and 37% prevalence, according to the World Health Organization. I will focus on the Arab region as that's where I'm located. And in line with how most of the world has been doing recently, most Arab states and reformers have resorted to legislating new laws that address domestic violence without necessarily addressing some of the serious reflections of this violence that are just lying there in their respective family and penal laws. This is still a good approach, yeah, to do the reforms through passing new laws or amending existing ones, because it is a move in the right direction towards changing the larger discourse that legitimizes violence against women in the domestic sphere. These domestic violence laws work on important issues of prevention, protection, prosecution, punishment, and the provision of reparations on violence against women. Most, however, do not fully comply with the state's obligation to due diligence, nor the United Nations model law. And in many Arab countries, the rest of the nation's legal framework is not yet harmonized with these new laws on domestic violence. And so this approach does leave us with the paradoxical situation where a law fighting domestic violence may exist side by side with other laws that perpetuate violence against women. Most Muslim family and penal laws are still based on the Qawama postulate that Dr. Lynn talked about, which treats men and women differently, giving power and guardianship to men over women. And this is where the issue is. We know from research that there is a strong relationship between gender inequality and the risk of violence against women. This inequality skews power relations, and when you end up legitimating it in the law itself, through male guardianship, male control, male authority over women, there is no escape from having to address family and penal laws that do that in order to really combat violence against women. So for example, you find countries that may have new laws combating domestic violence today, but their family and penal laws still allow varying levels of, and listen to this, wife disciplining or beating by the husband, child marriage, reduced sentences for so-called honor killings by family members. They exonerate rapists by marrying the survivors of their crime. They say nothing about marital rape. They allow husbands and male guardians to restrict women and girls' movement, access to education, work, legal services, signing of contracts, subjecting women and children to male authority and control. Many of these laws make leaving a bad marriage more difficult for women than men and give unrestricted rights to polygamy for men, notwithstanding the harmful repercussions on the wife and the children. When the guardian who controls women's lives and movements like this, in the name of protection, is himself the abuser, as is very often the case, how can we expect women to be able to report, escape, and seek help from domestic violence? It is sardonic that in some countries, women require the permission of a male guardian to exit a domestic abuse shelter. Now, if we look at the 1993 UN Declaration on the Elimination of Violence Against Women, we find that it defined violence as rooted in unequal power relations between the sexes. It defined violence against women as, and the words in between square brackets are mine. Can we have that? Yes, please, thank you. Any act of gender-based violence that results in or is likely to result in physical, such as disciplining the wife, child marriage, honor killing, sexual, such as marital rape, or psychological, unilateral verbal divorce, requiring women's obedience, threat of polygamy, harm or suffering of women, including threats of such acts, coercion, or arbitrary deprivation of liberty, such as male guardianship, male permission to work, go out, travel, and so on, whether occurring in public or in private life. Now, the above definition is quite important because it does not restrict violence only to physical or sexual violence, which has been typically addressed in penal codes in most countries. There are other forms of violence, such as psychological, economical, etc., alongside the physical, which we find reflected in Muslim family laws due to male guardianship over women. It's important to note that family laws are not the reason we have such high rates of domestic violence in these countries, by the way. It's the patriarchal system with its socioeconomic and political arms that uses the frame of the Muslim family law as a tool to fulfill patriarchy's interests and ends up inflicting violence, sometimes as acceptable collateral damage. So the law itself is not the root of this violence. However, when guardianship, which was originally meant to protect, turns into authority over women, skewing the power relation in favor of one party over another in discriminatory family laws, then these laws, of course, become an important contributing factor to the phenomenon of violence, and something must be done about them too. So now with all these caveats, important progress has been achieved through that particular law reform approach. And again, I'm talking about the law reform approach, which is passing either new laws or reforming like penal codes or other laws than the family law. So for example, today we have 8 Arab countries that have passed either domestic violence legislation or laws combating violence against women. We also witnessed a succession of reforms to penal codes across the Arab region on family-related issues, such as exonerating rapists from punishment upon marriage of their survivors. This approach is also not a bad one when it comes to addressing highly sensitive and stubborn issues, such as marital rape, for example. Because of the way jurists historically constructed the Islamic marriage contract, which is premised on nafaqa or maintenance by the man in return for tamkeen, obedience, or sexual availability by the woman, the issue of marital rape is very difficult to criminalize in Muslim legal contexts. Do note that marital rape was criminalized in the UK only in 1991. So this is not just a Muslim family law issue. And thank you very much, Lynn, for pointing out that earlier. Nevertheless, in Singapore, we find an interesting development that came in effect as of the beginning of this year, where marital rape was actually criminalized in the penal code for all Singaporeans, including the Muslim community, who are governed by the Muslim family law. Muslim religious leaders there announced their agreement with the amendment, saying that it is in harmony with Islamic law. Now, how did most of these reforms happen? In the paper, we present stories of reform using this particular approach from 5 different countries: Tunisia, Morocco, Jordan, Lebanon, and Singapore. And it seems that the most important factor that constantly comes out in all these stories has been what? What do you think? It's the activism of the local women's movement. No matter how restrictive or open the democratic space was in each of the countries examined, the women's movement was usually the main reason that action was spurred in the first instance. It was women's groups who felt the problem on the ground and translated it to advocacy campaigns pushing for reform. They lobbied around real-life stories of women who suffered in their countries. For example, Amina Filali in Morocco, who committed suicide after having to marry her rapist, who actually abused her even after marriage. Budur, the little girl in Egypt, who died during an operation of female genital mutilation, and many others, unfortunately. They moved to action with these stories, led protests, did all sorts of data gathering, research, and surveys to know more about the problem. They showed how these problematic practices and legal provisions departed from local values, paradoxically coming from sometimes Western colonial powers. Instead, they built on reforms that other neighboring Muslim countries undertook and learned from them. They used international human rights mechanisms to lobby for their cause and make it known. They talked with everyone, from women to government officials, parliamentarians, religious leaders, and so on. And so when finally the moment came where political will made its appearance, they were ready to jump and take that opportunity. By the way, oftentimes they were the ones who created that political moment and that political will. In the end, it's important to recognize that the reforms that took place through this particular approach are important milestones along the way towards gender equality and justice. They shape public discourses and contribute towards changing the meta-narrative justifying domestic violence. They are important steps of a cumulative effort towards change, which might not have happened if reformers had insisted on taking the more difficult route of reforming the family law from the start. So maybe, as a Moroccan member of parliament who had herself voted for the domestic violence law said, no law is perfect, at least now we have one. Let us always remember that this, however, is only the start of a long journey to eradicate unequal power relations between the sexes, including what has become a discriminatory guardianship framework underlying many of our laws and practices today. Thank you.
Thank you so much, Dr. Marwa. So in your talk, you've clearly shown us the link between family laws and the concepts of Qiyam and Wilaya that are embedded within them, and the link to the phenomenon of violence against women. And I find it interesting how sometimes when these family laws cannot be changed, or the concepts like Qiyam and Wilaya within them are too far embedded to touch, then looking at violence against women laws, domestic violence laws, marital rape laws, or reforming other laws like the penal code can then influence women's realities on the ground. And it's interesting, of course, that activism can help create the political will for change. I love that point about how it's the women working on the ground and the activists working, using scholarship, using ideas that are germinating around the world that can help create that. So far we've heard a little bit about constitutional and religious-based arguments from Dr. Zahia, and they're used to reform the substance of family laws. And we've heard about approaches that basically sidestep the family laws and instead focus on other laws related to the family. So another way to approach law reform is not to focus directly on the substance of the laws, but to focus on procedural change. And so again, I want to turn back to Dr. Lynn Welchman. And Lynn, I wonder if you could share with us some examples of procedural reform that can have an impact on equal relations in marriage. Thank you.
Thank you, Jana. And I'm very pleased to be following Zahia and Marwa. In this paper, we're using the term procedural approaches. Let me just check I've got my microphone on. Oh, okay. In relation to Muslim family law reform, to designate a bundle of interrelated measures. And these measures present as regulatory rather than judgmental or prohibitive. What they tend to do is to secure more tightly rights that are really not in dispute through giving them stronger oversight rather than taking on substance, which is more what we've heard from the previous two presentations. They may be built on and expanded in successive versions after being reviewed for effectiveness and changing circumstances. They can develop. These features may make them more immediately attainable than more absolute approaches to the substantive discriminatory parts of Muslim family law, and less liable to be dismissed as contesting understandings of the Shari'i postulate. Rather, they may be understood as upholding the objective of the public interest and arguably the ethics of care. It's hoped that as the expectations disseminated through such measures are absorbed and practiced, the targeted practices and attitudes themselves change, permitting further approaches towards equality and justice. It's useful to think of the procedural approach as implementation of changes, or in some cases, indeed, implementation of existing principles which are already established in the law. And often they lead to new and differently placed personnel getting involved in support of the objects identified in the law. I'm going to look very briefly, and I hope not too quickly, sorry, at registration requirements, court scrutiny, and notification requirements. 3 bits. I will consider these in relation to the efforts to reduce or eliminate child or early marriage and polygyny, and to strengthen women's access to their Shari'i inheritance rights. We have heard from Dr. Jouirou about the debate on inheritance rights, but it's also the case that often women find it difficult to access their existing well-established inheritance rights. Polygyny violates the principle of equality in text as well as in practice. Early marriage typically concerns females rather than males, so that even where the ages of marriage in the law textually don't differ, it's overwhelmingly girls and young women who suffer the very serious consequences of early marriage. Many civil society groups support the international consensus on 18 as the age of capacity for marriage as a legislative objective, and their efforts have succeeded in many Muslim majority countries. Globally, many states identify an earlier age at which exceptionally under 18-year-olds can seek permission to marry. Women's groups in Muslim majority states do not necessarily advocate against all such exceptions. Rather, as well as working for the age of marriage to increase in fact as well as in law, they may focus on increasing this exceptional minimum age and on the preconditions for permission to be granted for a marriage under 18. Through registration requirements, the state seeks both to expand its knowledge of the private lives of its citizens and to implement identified objectives of its codified law, such as regulating and reducing the incidence of polygyny and early marriage. States and legislators may justify the obligatory registration of a Muslim marriage on grounds of siyasa shari'iyya and the public interest. It is through the process of registration that court scrutiny comes into play, when the law conditions the court's permission for a particular type of marriage, so a polygynous one or one to a wife under 18, on certain requirements being met. Jordan's 2019 personal status law was a disappointment for those advocating for a rise in the exceptional age below which marriage would not be permitted, as this stayed at 15 years rather than rising to 16. Nevertheless, there has been an incremental strengthening of procedural safeguards through regulations issued at successive intervals by the Supreme Justice Department in Jordan to govern the granting of permission for underage marriage. Alongside conditions on consent and choice, for example, the regulations now specifically require the court to to establish that the husband-to-be in an underage marriage is not already married and that the marriage will not be a reason for the girl to drop out of school. Both of these have been significant concerns or are significant concerns for those campaigning against early marriage, and rigorous enforcement of such constraints could see significant impact on the incidence of marriage under 18. Similar concerns are echoed in different efforts in Morocco, where advocacy aims at setting a minimum age below the standard of 18. Here, those who Dorte and Gelke calls street-level bureaucrats get involved in implementing the law. Her research found that social assistants, who are often young women, are increasingly engaged with investigating whether, for example, permission being sought for an underage marriage is being sought because of financial pressures on the girl's family, that is, rather in the specific interest of the under 18-year-old girl, and whether the marriage will lead to the interruption of her school education. Some judges are reported to reject applications where it's an issue of marrying off daughters for financial reasons, for poverty. Others follow informal agreements amongst themselves to decline the marriage of anyone under 17. The social assistants are also engaged in investigating the claims made by Moroccan men in support of their applications for permission for a polygynous marriage. For example, those relating to the health of the existing wife and whether the existing wife has been informed of her husband's application to marry again. This brings us to notification requirements. This approach is based on ensuring that everyone involved in or implicated by a particular act has the necessary information to allow them to make an informed choice. This type of requirement is often used in efforts to regulate polygyny, and most commonly requires the court to ensure that the bride-to-be is aware that her fiancé is already married to someone else. Less commonly, and usually with greater opposition, the court is also required to notify the existing wife. And then there's the issue of whether this is to be done before the court may conclude her husband's polygynous contract or after the contract's been made. Opposition to such measures is at least partly recognition of the substantial challenge that may be posed to a man's decision if his existing wife is informed of his intentions, sorry about this, before the polygynous marriage is concluded. So this is partly to do with other forms and sites of power, adjusting the existing balance, even if slightly, in this particular circumstance, incrementally. In Palestine, a study by Johnston Hamami from Birzeit University documents a key shift in local legal reform strategies from a focus on normative justice to one more focused on procedural and cultural justice following the interim years after the Oslo Accords. Now, this is against the background of a very particular political context, but amongst the procedural directives issued by the Department of the Qadi al-Qudar, Chief Islamic Justice, was a circular to Sharia court judges requiring them to ensure before carrying out the marriage contract of a married man that the intended bride is informed that he's already married to someone else, and to notify the existing wife that the husband is intending to marry again. Also through notification procedures, the Palestine Sharia establishment has sought to protect women's access to their inheritance rights, an issue also of concern and lobbied on by women's groups. A first administrative directive sought to ensure that all entitled heirs know the monetary value of their portions before they agree to the formal division of the estate. And then a later one established a 4-month waiting period from the death of the deceased before heirs are allowed to formally waive their inheritance entitlement. Here, a combination of notification and administrative procedure requirements aims at protecting vulnerable women from being pressured into renouncing their Sharia inheritance rights, and to ensure that women have full information as to the value of their entitlement, should they then indeed choose to waive it in favor of another family member. These procedural methods of, if you like, ensuring rights that are already there and beefing them up, if you like, are of considerable significance in establishing different practices and expectations. And a number of civil society groups work quite hard on promoting their increased use alongside working on the substantive law. I hope this has been helpful, and I'm sorry if I spoke too fast.
Thanks so much, Lynn. I think it was very clear, actually. So, and we've gotten a couple comments to that effect. Thank you. So I find it, from your presentation, I find it just really interesting how these sometimes very, very small procedural requirements actually have an impact on how the law interacts with social realities, and that women can feel the effects of these procedural requirements very quickly, actually. And it doesn't take a lot of this cultural change that sometimes happens when there's a big overhaul of the law or a big overhaul of the provision. And as you said at the end, some procedural steps may be more easily introduced than going through a law reform or lawmaking process. And they can have as significant effects sometimes as changing the letter of the law, though both, I think, need to work side by side. Okay, so we have been introduced through these three presentations to a variety of approaches that activists and reformers can consider. So you could use thick and constitutional arguments towards substantive reform, and that is especially true in the case of religious resistance. You could look at other laws that are related to, but not in the family codes themselves, and you could look at procedural reform. These are different approaches that could be taken by activists. And so where I want to go next, and this is to close before we can get into the Q&A, and again, I want to tell the audience, you're welcome to ask questions in the Q&A, and you can also give a thumbs up or like so that we can make sure to prioritize those questions. So what do all of these approaches mean for the work of women's rights activists today? And what approaches have worked best? Where are there gaps? How can activists be more effective in pushing for change? And I think I'm going to turn to Marwa first. And I think if Lynn and Zahia want to add a moment or two at the end, that's fine. But Marwa, can you please help us think through these questions and just give us your critical assessment of these approaches that we've talked about?
Okay. So this whole paper started because we took a look at Musawah's Positive Developments Law Table. Yeah, it's right there on the screen, where Musawah tracked all the progressive law provisions on different topics in the Muslim family laws around the world. I mean, do take a look at this table, and it's very useful because, for example, on the issue of polygamy, it shows you how in Tunisia, for example, they banned it, but in Morocco, they put conditions on it, certain conditions, while in Pakistan, the conditions were a bit different, and so on. So it's a very useful resource. Anyway, so we looked at this table, and two things were obvious. Number one, that Muslim family laws around the world were different on how they handled any one family law issue. And the second thing is that they also gave us a colorful palette of different legal provisions, different options, if you will, on how to address any one topic in the direction of gender justice and equality. And so we asked the question, how did these positive legal provisions come about? If Muslim family law is so difficult to reform, how did different countries and actors manage to come up with this literally colorful palette of options we can learn from and use in our own different contexts? We found that they use different pathways or approaches to reform, which we tried to give you a taste of here, such as reform through, procedural law, reform through other laws, harmonizing laws with constitutional standards, judicial interventions. They also used a variety of references, such as religious-based arguments, human rights, national legal frameworks, and lived realities. Now, this paper shows us that we can use a multitude of different approaches or pathways for reforming family issues in Muslim contexts. Which approach you use is, of course, affected by the context you're in, and different approaches work better depending on the context. That is why, for example, in Singapore, reformers addressed marital rape through the second approach, which is reform through the penal law. They engaged heavily with the international human rights mechanisms whilst changing the law. Whereas in Tunisia, they adopted the constitutional standards approach, rooting themselves in Islamic religious arguments, supporting equal inheritance. When you read the paper, you're going to also see this dynamism playing out when you find, for example, a Moroccan judge resorting to the regular rape articles in the penal code to criminalize marital rape in one of the cases that came to him, whilst in the same time, his Tunisian counterparts refused to do the same, despite the presence of incriminating forensic evidence of the crime of marital rape. So each country, what does that tell us? It tells us that each country has its own particular playing field of law reform, where the four corners of the kite interact together. The national, international, can we have the other slide, please? The national, international, religious, and social. They all engage together in a conversation that is affected by the particularities of each context, which is why the outcome of that conversation is different in different countries. Additionally, the four corners are all affecting each other. We find that religious jurisprudence is changing as a result of the conversation with human rights. Human rights become adapted to local context. State law is changing to respond to lived realities, etc., and so on. So we find each corner of the kite evolving with this interaction between them. It's important to note here too that equality and justice do not hold fixed meanings in this process. They are also evolving and responding to the context. Now, as activists, studying this playing field and the possible interaction within it helps us to choose our strategies in activism. So what pathway of reform should we best take? As activists, we should also know that our power is being on the ground, engaging this conversation with women, governments, human rights, religious authorities to respond to what's happening on the ground. In the process, it's also very important for us to think, are the law reforms adopted through these various approaches or pathways? Are they actually changing the realities of women, or are they just token acts of unreal progress? What more needs to be done for the lives of women to be truly better? And how can we have change happen in a holistic way? This paper shows us that yes, it does take many years of persistent, consistent work, especially by the women's movement, but there will always be a pathway, if not more than one to choose from in this menu of reform approaches. And it's a pathway that can suit the playing field we find ourselves in. And so eventually, gradually and incrementally, we can then succeed in changing these laws and hopefully reality too, inshallah. Thank you.
Thank you so much, Marwa. Lynn and Zahia, would you like to add anything more about the critical assessment of these approaches? Should we get into Q&A? How do you feel?
Please, Jana, can I?
Dr. Zahia.
I want only to add that to succeed in this pathway for reforming Muslim family laws, we have to work together. We have to work together. The feminist organizations, the activists, the intellectuals, for example, in our example in Tunisia, the works published during this last 3 years concerning the inheritance laws, we have many works, published books and articles, and the intellectuals have a great work to do. But also the civil society, the parties, the political parties who are with the reforms, we have to work with, and and also with the parliaments. We have to work with the parliaments who are okay with this project. And I think that the way the Tunisian experience in reforming family laws had demonstrated that it is the result of together working between the political will and the work of the civil society, the work of activists and feminist organization, and also the work of thinkers and scholars and intellectuals, especially who are working from a Muslim framework reference, from framework reference from the religious framework. I think that it is very useful to bring all these actors to work together to let this reform possible.
Thank you. So that, I mean, I think that's a really important point about it's a variety of approaches. Sometimes one approach takes precedence over another, and working together is the way to strengthen the work in going forward. Lynn, do you want to add anything more now? Because I can
very briefly, just to agree with that entirely with both my co-authors and friends there, but also just a quick note, just I'm sure many people, because we have some wonderful people listening in who've been part of many of these struggles as well, so hello to all of you, is that you find allies in surprising places. And we all know that there is no monolith, none of these institutions, none of these sort of professions, and people have always found allies in surprising places because, yeah, so that's very briefly, Khalas. Thank you.
Great, thank you. So we have about 20 minutes for question and answers, and we're going to go into, if you look at the Q&A, if you are interested in any of the questions that are there and want to give it a thumbs up, you can do that, and we'll try to prioritize those because we won't be able to answer all of them. But we have basically clustered these with our colleague Sarah in the background. And one thing I want to highlight before we get into any of the questions is just, there is one question about sharing the paper that Marwa had mentioned. And this is a paper that is a work in progress. Doctors Lynn, Zahia, and Marwa are working on it right now. And this is, we hope, one of the products that will come out of this new initiative on reclaiming adl and ihsan in Muslim marriages. So stay tuned, that will come out hopefully in an edited volume form. So questions and answers. I think we want to start, it seems like the thumbs up go to one question about international human rights law. So this is something that you all touched on a little bit, but we haven't really gotten into very much. And so this is from our friend and colleague, Dr. Ruth Halperin-Kadari, who was served on the CEDAW committee for many years. And she said that she would like to know what your impression is of the impact that international human rights regime has actually had on the possibility for reform. So how has the international human rights regime actually affected the changes of laws, the law reform? And Dr. Marwa, maybe you want to start with this?
Sure. So it's a mixed answer. Definitely it has been helpful, but it has been also very tricky in certain contexts. You do know that, I mean, I'm going to speak about the Arab region. In many contexts here, human rights is regarded as basically a Western plot to destroy the Muslim family, yeah? And so you have to be very careful when you refer, even though Arabs contributed to writing these human rights declarations and treaties, but still that is the context which, the way in which it is seen. So that said, on the other hand, the human rights system is also a very powerful tool for activists to be able to have their voice out with their governments when they sometimes can't do that in their own local context. And so, of course, you know that Musawah has been, since 2011, has been very active in all the CEDAW committee, constructive debates and dialogues there in Geneva. And we've seen it with our own two eyes, how in many cases activists are unable to talk about certain things back home, but then they come to Geneva and they're able to talk with their governments about them. And so this is it's the process itself also that is very important. Of course, sometimes it's very dangerous for them to do that, and they cannot speak, not even in Geneva, because there's a threat there. Now, the question is something that we do ask ourselves also in our engagement with CEDAW, really. It's what happens after. So, sorry, I'm going to backtrack. So in many of our countries, we see that right before the constructive dialogue, governments suddenly remember women and they pass laws or they pass policies in order to go to Geneva and look good, okay? And we've seen it happen not just in the Arab region, it's all over the world. So that happens. But then what we're really also interested in is after Geneva, you know, the concluding observations. How can we work with these concluding observations on the ground to keep the momentum going, yeah? And this is very important for us in Musawah, especially in our campaign for justice that Jana talked to you about. And we do have examples of state delegations where their engagement with the CEDAW process has actually borne fruit. For example, some laws have been reformed, as we have seen last year in Afghanistan. And my colleagues have sent me some of the examples. In Kenya, we saw some interest by government in reforming the Qadi court system. Kuwait, We are seeing now movement on reforming the domestic violence issue, and they just passed a law on domestic violence in Kuwait, and so many other things that are happening. So it's really, my answer to you is, of course it's useful, and sometimes it's absolutely not, and we have to be very careful. Sorry for this very confusing answer.
Could I add one thing to that?
Yes, please.
Yeah. I think also, just in terms of it's sort of, again, it's a sort of procedural thing almost, that given that all state signatories, that parties, they have to produce certain information, gender desegregated data, the whole institutionalization of the idea of looking at things and women's role in them, and also that's actually very important, the data, and the process of producing it is a method also of, if you like, mobilizing whole institutions around the idea of how the world looks to women and how women look at the world. And that actually, that data information is very important to struggles across the world in terms of just being able to say, but listen. So I think that's not to be, that doesn't make the change, but that can be useful in making an argument. That's not to be dismissed. I think that's another thing to think about as valuable, but that's my procedural brain thinking. That's very good. So.
Zahia, do you have anything to add?
Yes, I want to answer Ken Myers. I want to say that to know, because I'm working, I work especially on the Arabic.
Is this his question about inheritance that you're answering?
Yeah, yes, yes.
Let me just phrase it so that others can know what you're talking about. So he's asking about different interpretations and understandings of law, such as inheritance laws. And what sources do we have to see in how inheritance was handled in actual cases? Who studies this data? What kind of researchers can we look to for this data? This is the question you're answering, right, Dr. Zahia?
Okay, thank you. Then I said that because I'm working especially on Arabic resources, classical resources, but also on Arabic modern resources, to know how different interpretations and understandings of laws we have to look after the tafsir, how the mufassirin had been understanding and interpreting the Quranic verses. When we look to the tafsir, we find such big differences that all what they say about the immutable inheritance verses is not true. And to know about how the inheritance were handled in actual cases and in lived realities, we have to look after the fatwa, the jurisprudence, the fatwa, because the fatwa is usually a question from one Muslim to the faqih. The questions make us aware about such a great difference between what is said in the fiqh resources, what is and what is done in the reality. In reality, we find that during history, the women don't have even the half share. They don't have even the half share, because there's other laws like the habus. The habus is it's a social constructed for looking after the family property, to let only the men use this property, not the women. There's many cases where we find how the inheritance was handled in the lived reality. We have to look after the resources like the fatwa resources. And I want also to say something about there's a question from Mr. Khalid Masoud, who said we should also discuss economic equality with reference to inheritance, Islamic legal tradition relating to mahr, nafaqa, property rights, and these Islamic legal tradition could be taken as direction for developing economic rights further. I want to say to Mr. Khalid Masoud, during our debates with the Tunisian ulama, we say that we have to distinguish between the inheritance, the common family property, and the women self-acquired property. But they say that all these property concern what is the property that come to the family, to the couple, to the married couple during their life, during their common life. They look at it as a part of the inheritance. But we are aware that we must distinguish between the inheritance laws and the family property laws and what is acquired by the women themselves. It's not the same thing. We have to distinguish between this. Effectively, inheritance laws can't be taken as only one, as only the only law that guarantee the economic equality. The economic equality must be looked at from other points of view. For the Tunisian project for equality in inheritance, it is ratified by the government and it is now in the parliament. That's all the questions that I...
Thank you. And I think your point actually gets at some of these nuances of how inheritance and Qawama and Wilaya are all intertwined. And so inheritance sometimes is within a family law, it sometimes sits in its own separate laws, but they are so closely intertwined that, and a lot of times the arguments made for the inheritance shares are intertwined with why Qawama should remain. Lynn and Marwa, did you have anything to add about inheritance, or we can move on to the next? No, okay, great. So the next set of questions is, I want to get to the one addressed to Marwa about BAO laws. So the question is, the laws addressing violence against women are important milestones. I wonder if you can tell us how you view next steps to build on these milestones. From your perspective, what are steps that could be taken to better implement these laws? How do you get the implementation going? How could police be trained to take these laws into account and work to enforce them appropriately? And actually, you may want to also then talk about how activists can play a role, and this may get to Lynn's questions about and presentation about procedural reforms as well. Marwa, you want to take that?
Yeah, sure. So obviously in my presentation, I also tried to say that it's not enough just to work on domestic violence laws. We also need to work on the other laws, like the family law, the penal codes, and even labor law, I mean, the constitution that encourages, sorry?
And procedural law.
And procedural law that actually encourages violence, yeah? So let's not just focus on domestic violence laws. Having said that, of course, there is plenty to do with domestic violence laws. Number one, we need funds, yeah? There are structures that are being started in these laws. You need funds to implement. And these laws need to be complemented by national action plans, by national strategies. You know, you can't just say, I have a law and be happy about it. No, how are you going to translate it into reality? And this is still missing in a lot of the countries here. You know, you need to be able to set goals as a country, as a nation. That includes working with civil society, medical organizations, you know, as you said, police forces. By the way, a lot of these laws, the Kuwaiti, Tunisian, and Lebanese one, if I remember correctly, they all have clauses punishing police officers who pressure women to retract their complaints of violence against them in the police station. So, okay, do we have the mechanisms to actually implement that clause in the law? It's a wonderful clause. It's great, actually. So we need to think a step ahead, you know, implementation. I think it's also important to acknowledge in some of these laws, because it's not there. And when you look at the Lebanese law, it's very, very obvious, because the Lebanese law is the language is very gender neutral. It does not take into consideration that women especially are, you know, because of their gender, they're at a more risk of violence in the family. Of course, with COVID, new things started to come up. In Palestine, for example, the hotlines there around April, May of this year, they started receiving calls, believe it or not, not just from women, but from young men. Yeah. So of course, yes, yeah, there are other people who are suffering from domestic violence, but typically it has always been the women who have been structurally in a fragile situation. And this needs to be acknowledged by the laws because it's not there. And of course, also the definitions of violence in the law. Yeah, sometimes it's very narrow. And like we have a very good practice in Algeria in 2015, they passed an amendment where former spouses were included under that domestic violence kind of remit. Yeah. Yeah. So this is more or less what I would say, that we need to look at. This is just the start, as I said. We need to look at implementation, you know, funds, involving other actors with us, more or less. Yeah.
And did you have something to add?
Me?
Yes.
Oh, I'll always talk given the chance, but not to that particularly. But I did want to pick up on one question, if you don't mind, from Christina Yarouche, who said, in Jordan, unfortunately, we have cases where women don't support women's issues. And I think, Christina, if I think that's the case in every country around the world. You know, and that's how it should be. We shouldn't have a monolithic idea of what it is to be a woman. So in that sense, we're all dealing with that complexity, and we have to respect and make the arguments. Women and men. So I think that's not an issue, really not an issue that only faces perhaps surprises or challenges Fil Urdun in Jordan. So that's all. I just wanted to pick up on that question. So I don't know if Marwa would agree with that, I think. No.
Yeah. So I want to get to the next set of questions about dissemination, knowledge, capacity building, and education. So somebody is asking how, so the appreciation, I think we've heard the appreciation and comments and the Q&A of the Musawah efforts to produce knowledge, to raise awareness. And the question is, how do you get these nuanced and well-founded interpretations integrated into systems of education so that people who will become legal authorities can hear this? Does anyone want to take that one on? And I know this is an issue that we've talked about in countries around the world. Lynn,
I think that one's, I'm going to volunteer Zahia for that one. Are you up for that one, Zahia?
You want me to repeat the question?
Yes, please.
So we are demonstrating some of these very nuanced interpretations that are scholarship that's being developed. How do we get this scholarship into the academy so that those who become legal authorities know it and feel informed by it enough in their work going forward?
Can I quickly say something as Musawah? Yeah. I can quickly just say something, because Musawah's work and publications are now being taught in universities around the world. Yeah. So this is one way of doing it. From Western universities to Arab universities to Asian universities, it's all over. But it's not just education. It's very important to bring in art here, art and culture. And if you've been following our campaign for justice, you know, what we've been releasing so far, we've been trying to do that as well. Songs, videos, films, you know, art, it reaches people. This actually sometimes is even more important and transformative than when you read a book, unfortunately. Yeah, this is the age we live in. So I think we should also, as feminists, expand a bit. I mean, we're comfortable with reading and writing and protests and all that. There's another element out there involved, and I'm sure we all know it, yani, and enjoy it as connoisseurs of art. But this is just one thing I wanted to bring forward.
Lynn kind of smirked when you said it's more important than reading books. So, Zahia, do you want to talk a little bit about
I agree.
how these interpretations are used in the academy, in your experience and experience with others? How are they being taught in universities and taught to legal authorities?
We work at the university with the students. Especially, we have groups of research. We have a laboratory of research with the students. Many of the publication about, for example, about inheritance laws published in Tunisia during these 2 last years, we find participation of students, of PhD researcher, of students of master research. That's one group of working, but we work also with the jurists, in the Faculty of Laws. We work with them to give another point of view about because in Faculty of Laws, the students have a course about Islamic laws. We are all aware that this course must be done by someone who have new approaches, who have new ideas. We can't only use the classical knowledge. We have to give the students the new knowledge about the Sharia, about the Islamic law, about the different schools, and but also I think that it's too interesting to have an idea about the strategy of Musawah. We use the same strategy. Musawah work on three interesting points. Knowledge building. We can't do anything without building knowledge, a new knowledge. We have to build a new knowledge about each project we want to work on. We want to work on changing the inheritance law. We have to produce a new knowledge about this subject. Then the first point is to build a new law. No.
Okay, very quickly. Very quickly, because we're almost out of time.
We have to build a new knowledge, and we have to use the research, the universities, the different institutions of research in the university, in different. Then we have to make advocacy. It's too interesting also to have advocacy. We work with parliaments, we work with politicians, we work with civil society, with feminists, each one who is interested in this subject, we work with. Then the third point is to work on changing laws. We have to change, because if you want to change mentalities, that demands a lot of time. It's a work that must be done in a long time. But if we want to change a bit quickly, we have to work in changing laws. That's why I think that this strategy is very interesting.
And I must say that Musawah has really been inspired by and learned from our colleagues in the Maghreb from the beginning. And so we thank you for that, for your activism. And Dr. Zahia just basically said what I was going to say: advocacy, law reform, reform of laws, and education, of course. And for those of you who asked questions in the Q&A about resources, our colleague Sarah has put them in the chat, so please refer to those. And then I just want to thank Drs. Lynn, Dr. Zahia, and Dr. Marwa for sharing their time and insights today. It's been really inspiring and just fascinating to hear what you have to share with the world. So be on the lookout for the paper that this trio of scholar activists is writing, and that will be featured in a Musawah book that we hope to produce in the next year or so. So I'm going to close it here. Please don't leave yet, because I'm going to turn it back over to our housekeeper, Sarah, who will launch a quick poll and say a few words in closing. And we really hope that you can all take this poll before you leave. Thanks.
Thank you so much, Jana, Dr. Zahia, Dr. Lynn, and Dr. Marwa, for this extremely captivating conversation and for taking us through the intricacies of family law reform in Muslim context. I also want to thank our audience for your constructive and valuable questions to the speakers. But before you leave, can I ask you to please answer 2 questions in our poll that our colleague Suri will launch now, and that you will be able to see in your screen. If you enjoyed this webinar, there will be more, inshallah, on ahadith, on Qur'an, and more focused on the textual tradition. We hope you will be able to join us. Please check our website and follow our social media pages for more information. I also would like to thank the amazing team that is behind the organization of this webinar. Of course, Jana, Ziba, Mulki, Hishama, Suri, Alex, and other colleagues that are supporting us in Musawah. And the recording will be available on YouTube in the coming week. And if you have any follow-up questions about this webinar, the series, or the research initiative, you can email us at sarah@musawah.org. And I will just, we will all just stay on for a couple of minutes to just give you enough time to share feedback. And please also don't hesitate to write to us and contact us via email to share any comments, suggestions for future webinars or for Musawah in general.